Ladies and gentlemen, we'll get right here. Welcome to the Pennington County Planning Commission meeting of October 24th, 2022. Recommendations to the Planning Commission on certain items from the agenda will be considered by the Board of Commissioners at their regular meeting on November 1st at 10:30 a.m. The Planning Commission utilizes speaker request forms which are available in the commission chambers. They're in the back corners. And I did receive a couple. There's apparently a couple of people already put some in this morning. We'll go ahead and take a roll call. On roll call, everybody's here. Jerry? Everybody get a chance, item number 1, to review the minutes from the October 11, 2022 meeting. Chair to address a motion.
Mr. Chair, move to approve.
Second.
It's been moved and seconded to approve the minutes from the October 11th, 2022 meeting of the Pennington County Planning Commission. Discussion from the audience. Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. Approval of the agenda. Have you had a chance to review your agenda book or on site? Chair would address a motion.
So move. Second.
Moved and seconded to approve the agenda for the October 24th, 2022 Pennington County Planning Commission. Discussion from the audience. Hearing none, all in favor of the motion signify by saying aye.
Aye. Aye.
Opposed? Motion carried. On to the consent agenda. Jason?
Morning, Commissioners. Jason Fennington, Assistant Planning Director. The following items have been placed on the consent agenda for action to be taken on all items in accordance with staff's recommendation by a single vote. Any item may be removed from the consent agenda by a planning commissioner, staff member, or audience member for separate consideration. The findings of this planning commission on certain items from this agenda are recommendations to the Pennington County Board of Commissioners, who will make the final decision. Agenda item number 3 is conditional use permit 16-30 for Paul and Carol Neiman to review an accessory structure, a pole barn, prior to a primary structure on the subject property. And staff recommends approval of the extension of conditional use permit 16-30. Agenda item number 4 is conditional use permit 18-13 for Randy Wartzfeld to review a 12-by-12 cabin to be occupied on a seasonal basis on the subject property. And staff recommends approval of the extension of conditional use permit 1813. Agenda item number 5 is conditional use permit 21-16 for Kyle Brown to review a caretaker residence on the subject property. And staff recommends approval of the extension of conditional use permit 21-16. Agenda item number 6 is conditional use permit review 21-39 for Paul and Carol Neiman to review a recreational vehicle park on the subject property. And staff recommends approval of the extension of conditional use permit 21-39. And lastly is agenda item number 7 for minor planned unit development amendment review 19-08 for Joel and Elizabeth Morris to review living in a recreational vehicle as temporary living quarters while building a single-family residence. And staff recommends to end planned unit development amendment 19-08 with the applicant's concurrence.
Thank you, Jason. Jason, any items from the staff that would like to pull?
No, sir.
Commission, any items from the commission that you'd like to pull?
Mr. Chair, item 4.
Item number 4.
Mr. Chair, item 6.
Item number 6. From the audience, anyone would like to have an item pulled for discussion? Okay, and it is understood that these are passed by one vote of the commission. All right. Commission care to make a motion?
Mr. Chair,
Yes.
move to approve items 3, 5, and 7.
Second, is there a second? Moved and seconded to approve consent calendar items number 3, 5, and 7.
Who made the motion for the second?
Kevin,
Okay.
any additional discussion from the audience? Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. On to item number 4.
I'm not necessarily opposed to this. I was just questioning, I wasn't here at the last meeting. So it says it's continued from October 11th, and yet it's on the conditional use. So I'm just wondering for clarification on, was it heard at the last meeting and now it's a consent agenda item and we're not voting on it again? Or just help me understand that, please.
And Talmadge Planner. I believe it was just a review that I didn't have enough information on, so I continued it from the previous meeting. I recommend to continue it.
Okay. Thank you. Mr. Chair, I'd move to approve item number 4.
Is there a second to that?
Second.
Moved and seconded to approve conditional use permit 18-13 per staff's recommendation with 15 conditions. Anyone from the audience want to speak on that? Any discussion by the commission? Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. On to item number 6.
Item
If-
number 6, I just have a question. I've got a lot of friends and family, but I can't imagine having 6 RV sites for friend and family. Is this a holding pattern until it's built and then they will, set it up for a commercial operation? Or is this a legit deal that it's just going to be for friends and family?
Kelsey Roush, planner. This is only for friends and family. He lives down in Custer. He has a bunch of family from out of town. They just like to come to the hills and spend some time together in the summers. They're not even set up and ready yet. The electric is in, and then the septic is in. He has a conditional use permit, as you saw, for an accessory structure as well. They just store all their fun toys here is the plan. And then they're just gonna come out and spend a couple weeks together and that's it. That's his whole plan.
Okay, well, it's his land if that's what he wants to do.
Yeah.
Mr. Chair, I have no further questions.
All righty. Commissioner Lewis, would you like to go ahead and make a motion
I
then?
would make a motion that agenda item number 6 be passed.
Is there a second to that motion?
Second.
Moved and seconded to approve conditional use permit 21-39, which was a review per staff's recommendation. And I was just looking how many, there's 18 conditions, I believe, that apply. Anyone from the audience that would care to discuss this? It is open for discussion and not on the consent. Anyone from the commission? Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. On to item number 8.
Megan Talmadge, planner. Item number 8 is CU 22-44 to allow an accessory dwelling unit on the subject property. The applicant is Rodney Alexander. The lot size is 1.6 acres. The current zoning is rural residential district. There is a correction on existing land use. It is residential. The access is off of Deerfield Road and the flood hazard is Zone A. The zoning ordinance lists 7 criteria that the planning commission may consider in their review of conditional use permits. They are listed on the screen. Number 1, no. The requested use should not be detrimental or endanger the public health, safety, or general welfare. 2, no. The requested use should not substantially impair or diminish the uses, values, or enjoyment of other property in the neighborhood for purposes already permitted. Number 3, no. The requested use should not impede the normal and orderly development and improvement of surrounding property for uses permitted in the district. Number 4, yes. An address will be assigned for the ADU posted in accordance with Pennington County Ordinance Number 20. Access is off Deerfield Road.
Megan, can I have you just lower your mic just a little? You're just a tad soft today. Thank you.
5, yes, the existing approach will provide ingress and egress to minimize traffic congestion on Deerfield Road. The ADU will utilize the same driveway approach as the primary dwelling. Number 6, yes, the current zoning district is rural residential. The requested use will conform to all applicable regulations of the district if this conditional use permit is approved. Number 7, yes, future land use is identified as rural residential. The requested use is consistent within this district and with an approved conditional use permit. Staff has reviewed the criteria for an ADU and it meets all uses. For property history, there is a double-wide mobile home with a deck, and there is a current operating license. In the interdepartmental review, there were no major comments or concerns. And on October 13th, staff performed the site visit and found the double-wide mobile home on the property, and staff finds no significant issues with the applicant's request and recommends approval of CU 22-44.
Thank you. Questions for Megan? Go ahead.
On page 4, under property history, are there 2 septic tank systems already?
No, there's just a single one, but I put when it was installed and the current operating license.
Okay, so the second one that they want to put in, this cabin or whatever it is, it will use the existing utilities?
Yes.
So it appears to me, by the time you're done with this, you're going to have 2 freestanding units that both could be long-term rentals.
Yes.
Okay, thank you.
Megan, just a question is, there's a carport sitting in the piece of property just the other side of the road, the approach or the access. Have you noticed that in there crossing in your picture or your drawing that the applicant submitted? That's the easiest place to note where it's at. It's right across from the house right now. It's sitting on the Deerfield side of the property, right up there.
I was not the one who performed the site visit, and I actually did not notice that.
And I just wondered whether that was going to be a part of the final construction or have we already signed off on the building permit?
The building
That was the
permit
only question I had.
for the double-wide mobile home or for the ADU?
Yeah, I thought it was going to be at the double-wide mobile home, the way they set up the gravel and everything. I assumed they were going to move it over to that. But we do look at whether it's attached to the ground, not attached to the ground, all sorts of things. So that's what I was getting at. Was it under our building permit for the first one, or we've got to get it in there if it's going to stay there? It's sitting kind of in the weeds right alongside of Deerfield right now. Is the applicant here?
No, he is not.
Can you find that? It isn't anything I think we should hold anything up for. I'm just saying we got to
Yep,
make
he
a
did.
resolution on it. Go ahead, Jason.
So the applicant does have a building permit for the double wide that's on there now. What he's applying for now is to add that accessory dwelling unit that you can see on the map there. He does not have a building permit for that yet.
But I wasn't getting it. There's a carport, a metal carport sitting right across down the access road, right alongside of Deerfield Road on that property
Okay.
that hasn't been attached. It's just been sitting there for a couple, 3 years now. And I would assume it was part of the double-wide movement because I think the double-wide's probably been occupied for darn near a year. It shows, I don't think we've got a picture heading that direction. That's why it's in the little triangle right across from the building.
Okay, we'll have to research that to find
Yeah.
out because.
I'm just saying, I think we ought to get it resolved. It shouldn't be just left there sitting in the weeds. It's kind of tipped and.
Okay, yeah.
Yeah, we'll talk to Dwayne. He did the site visit.
Yeah.
We'll see if he noted one out there. It may not be on the applicant's property, but we'll definitely research it.
Thank you.
Sure.
Appreciate it. Any other questions from the commission? Anyone in the audience here today to speak on this?
Mr. Chair,
Yes.
I appreciate the good feedback on this. I will make a motion to approve conditional use permit 22-44 with the following conditions, which are 16 conditions.
Second.
Moved and seconded to approve conditional use permit CU 22-44 per staff's recommendation with 16 conditions. Discussion. Any discussion from public? Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. On to item number 9.
Item number 9 is conditional use permit, CU 22-46, and is to allow a vacation home rental on the subject property. The applicant is Brian Baxter through KPJP LLC. The lot size is 3.62 acres. The current zoning is suburban residential district. The existing land use is residential. The access is off of Pioneer Circle, and there is no flood hazard on the property. The zoning ordinance lists 7 criteria that the planning commission may consider in their review of conditional use permit applications. They are listed on the screen. 1, no, a vacation home rental takes place entirely within an existing residence. The requested use should not be detrimental or endanger the public health, safety, or general welfare. Number 2, no, a VHR is considered a residential use. This requested use should not change the use of the property or have any long-term negative effects on the use and enjoyment of other properties in the immediate vicinity. Number 3, no, the requested use should not affect the normal orderly development or improvement of any surrounding property in the area. Number 4, yes, all necessary utilities are in place. Number 5, yes, access is off of Pioneer Circle via an existing approach. The requested use should not significantly affect the traffic congestion. 6, yes, the property is zoned suburban residential district. An approved conditional use permit is required to operate the vacation home rental in the zoning district. Number 7, yes, the future land use is rural residential. Allowing this conditional use permit should be consistent with the current comprehensive plan. There is a single-family residence built in 1980 per Department of Equalization records, and there is a current operating permit on the property. In the interdepartmental review, there were no major comments or concerns. On October 18th, staff performed a site visit and found smoke detectors in each room and fire extinguisher on all 3 floors. Both BTJIA, which is the LLC listed on the tax license, and KPJP LLC are member managed by Brian Baxter. And staff recommends approval of CU 22-46.
Okay, before we go on, I want to check and make sure we do have a person on Zoom on this matter. I believe it's Mr. Baxter. Are you there?
I am.
Okay, I just wanted to make sure you were able to hear the discussion if there's any. You can't hear
sir.
that. Thank you. All right, questions for Megan?
Question and a comment. This is near Clarkson Road, and if I remember rightly, we've had a fair number of vacation home rentals in this area. Do you have any idea in this immediate area how many vacation home rentals there are?
I do not, but I can look into it.
Like I say, I know we've okayed some along the way, and there's been some discussion and neighbors, talking about it. And that's why I was just curious. So other than that, there's not much I can say.
Go ahead, Karen.
On condition number 3, that the property permits be obtained prior to utilizing a fire pit on the property, and all fire restrictions be followed at all times. When you look further through the documentation, property rules say the use of open fires, fire pits, fireworks, charcoal burning grills, blah, 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 shall not be allowed without permission from local contact or owner. And then under rental rules, it says absolutely no open fires, fireworks, or sparklers. So I guess I'd like those 3 to match. That's pretty vague.
Thank you, Karen. I had the same question, and I think if we stick by what the department has come up with, those 2 rules, they cover whether people change their mind along the way, so to speak. And the number 3 that's in there just doesn't cut it with me. We've changed it to a 2-condition setup that I believe we've been using now for about a year, haven't we? and I would like to see that included. And then I had one question on my own, and you know I'm going to pick on this. I see that there's a sales tax license under one LLC, and then we have the applicant is another LLC. And you know I'm not fond of all that and doing business. Megan sits here, if something goes wrong or we need to pursue an action, we have no idea who we're doing business with. And I think we've got to quit doing that. So our ordinance says that the applicant or owner, I guess, has to be the one that holds the sales tax license. So at this point in time, I would say we have an incorrect sales tax license. The last one we did this on, they had to continue until they got their license the next time. Jason, whatever you'd like to say on that comment.
Sure. So Megan did research the Secretary of
Okay.
State's website, and those are both member-managed LLCs, both listing Brian Baxter, the applicant, as their agent.
Okay.
So his name is directly tied to both of those LLCs.
But which one is the applicant for this one? Isn't that one?
The KPJP LLC.
Okay. LLC means limited liability. So that means if we've got a different company than the person that's holding the conditional use permit, it would appear to me that that's different ownership. It's limited to that liability. I don't know. That's my opinion. It's not in the same as, now whether he has to have two, there's a lot of businesses have more than one sales tax license. We get loose on this, and limited liability means you can only go after them for whatever assets they say and this sort of thing, and most of them aren't worth pursuing the way the rules are set up. It's a very strict structure. My opinion only. Commission can certainly comment on what my thoughts
Well,
are.
if you look
Go
at
ahead.
the Secretary of State's business listing on this, which I did the other day, it just lists the LLC, it lists Brian Baxter, and it lists his Pioneer Court. That's it. I mean, it's there, but it doesn't show anything more than that.
Can I explain though, on LLC is just like stock ownership or partners. You have that and it applies to a specific set of items that are assets under that LLC. Another LLC can have the same name, same partners, and have only those assets under that LLC. It's different. I don't care whether it's the same owner, it's different because it's limited by law to that, in my opinion. Megan, do you want to chew on me on that? Am I coming off the wall here in the wrong place?
I'm confused as to what the question is.
The question is our ordinance says that the, can I have you come up and then you can just, our ordinance specifies that the sales tax license has to be in the name of the owner.
Yes.
Okay.
And what is the issue with this?
If the sales tax license, for instance, is in the name of a different LLC, doesn't that constitute a different owner?
Well, it depends on who owns the actual structure. Does the LLC that,
That's a good point.
I mean,
Whether it's an asset of the LLC.
exactly, yeah. I mean, it depends on which LLC owns the actual structure. I mean,
Could we solve this by Mr. Baxter and then go ahead and pass this
Sure.
thing by doing a DBA that he's the one responsible for both, or?
I mean, a DBA doesn't really fix the issue of who actually owns the
Okay.
property. I mean,
Sure.
is he actually here to say
He's on Zoom.
who owns the
He's
property?
on Zoom.
Okay. I think that he should
I'm here.
probably answer that
Go
question.
ahead. Can you direct us on that?
Well, I don't know that I understand the question. So I personally own the property, but the property is contained within the LLC that you're talking about, KPPJ, and that is nested under the overall LLC, which is BTJIA, which is also owned by me. So I own the property. I have the two LLCs, which are all me. So I don't know that I understand it. It all is me. There's no separate ownership of anything that doesn't have my name associated with it.
I mean, based on that, I think it should be fine.
I guess I'm not totally in agreement with that, but because I know, I've got to ask you a question. Why would you have both LLCs if it doesn't assist you financially from exposure?
Well, in all fairness, because it was the recommendation given by legal counsel at the time that I set up the LLCs, and it's not I have an umbrella LLC that contains other entities other than this property. So it's just an overall organizational structure.
I would think it is good legal advice because under the laws of South Dakota, the LLC is very limited as to its exposure and other people that would pursue claims against you. So,
Correct.
but it still represents whether your name's on both of them. I'm not sure that qualifies you to go ahead and become a different person in your sales tax license. But what would I say? I'll stay out of the way and let the state worry about it. I guess the only problem we would have is whether you paid your sales tax then, wouldn't it, Brian? But other people might have a lot of problems with one LLC owning another and another. This can get pretty deep and pretty mucky. So, but I'm gonna remove myself in that question. I guess if the same person holds the sales tax license on both, I guess I'm gonna go with what Megan says.
Mr. Chair,
Yes.
I will concur with you, though. When you look at the Department of Ag and Natural Resources under KPJP LLC, and then you see other documentation in the packet that says BTJIA LLC, that is very confusing. I'm not an attorney, but when I do my sniff test, it doesn't smell good. So I think in the future, when we have applications, that they should all be the same LLC. Maybe it's just totally fine, but it's confusing to us, and I think we ought to be looking at how we do business in the future relative to being consistent throughout the whole ownership.
Thank you. Anyone else have anything?
Charlie, I'd like to go back to that condition number 3. I wondered if Mr. Baxter would be willing to change the language on that to what he has in his property rules, that there's no smoking, open fires, fireworks, especially the open fires, I think, rather than that proper permits will be obtained.
Yes, ma'am. Absolutely. I have no desire for fires there. So.
Okay, thank you.
Mr. Chair.
Yes.
Mr. Baxter, can you hear me?
Yes.
Do you have any adjacent neighbors at our vacation home rentals, or are there any in the immediate neighborhood?
Yes.
Okay, thank you.
Any other questions, discussion? Questions for Megan or Mr. Baxter? Anyone from the audience that would like to speak on this before we address the motion?
Mr. Chair.
Yes.
We got one more. Jason, could you come up for a second? I had a phone call earlier today about vacation home rental in a totally different neighborhood, and he didn't like what was going on there. And so item 16 here says that the permit can be reviewed in 1 year or on a complaint basis. My question is what constitutes a complaint? Obviously, our sheriff's department does not want to go to these things because of loud noise and too many people parking. So I guess the question is how many complaints does a person have to have, but what constitute a complaint before, somebody could lose their license?
Right, so the way the process works is that we'll get a nuisance complaint from the complainant. We'll give that to the ordinance officer, and he'll go out and substantiate the nuisance. And if it is substantiated, then we'll bring that in front of the planning commission for hearing again. But if it's not substantiated, we can't bring that forward.
I know you guys are redoing the vacation home rental ordinance, and
Right.
hopefully there can be something with a little more teeth to make sure that these people follow the rules.
Thank you. Any other discussion? Chair to address a motion on item number 9.
Move to approve conditional use 22-46 per staff's recommendations.
before you ask for a second, that would include the revision of number 3 to his
To reflect the revision of
wording.
number 3.
Okay. Is there a second to that motion?
Second.
Moved and seconded to approve conditional use permit CU 22-46 with 16 conditions. Condition number 3 to be switched to the same wording that's used by the owner in regards to, what would you say, fire and open flame. Will that work, Karen?
Yes.
Okay. Discussion from the audience. Anyone care to speak on this before we? From the commission? Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. Thank you. On to item number 10, I believe. Yes.
Cody Sack, environmental planner. Item 10 is conditional use permit CU 22-47. It's to allow a contractor storage yard on the subject property. The applicant is Travis Chrisman, the landowner is Theodore Chrisman. Location of the property is 11905 Reno Gulch Road, involves 70.47 acres. Current zoning is agriculture district with existing land use of residential. Access is off Reno Gulch Road, and there is no special flood hazard area on the property. The zoning ordinance lists 7 criteria the planning commission may consider in the review of conditional use permit applications. The answers are on the screen. I'll read them out loud. Number 1, no. Allowing this conditional use permit should not be detrimental or endanger the public health, safety, or general welfare of the public. Number 2, no. The requested use should not have any negative effects on the use and enjoyment of other properties in the neighborhood. Number 3, no. Allowing the CUP should not affect the normal orderly development or improvement of any surrounding property in the area. Number 4, yes. The subject property is accessed via Reno Gulch Road, which is 17 to 24 feet wide gravel road. The property is serviced by private utilities. Number 5, yes, ingress and egress would be provided through approaches off of Reno Gulch Road. Number 6, yes, the proposed zone, the property is zoned agriculture district. The requested use may be allowed with an improved CUP. And number 7, yes, the future land use of the subject property is ranchette. Allowing this conditional use permit is consistent with the current comprehensive plan view to 2020 or 2040. Currently on the subject property, there is a single-family residence, a 24 by 18 carport, a 10 by 20 carport, a 19 by 40 carport, and a 40 by 76 agriculture structure with a bathroom, all of which have approved building permits. And there's 2 on-site wastewater treatment systems, one that services the single-family residence and one that services the agriculture structure. This was read around for a new department review. There were no objections or concerns that were received. The applicant is proposing to store construction equipment on the subject property. The equipment will mainly be on the job site, but sometimes the equipment will be stored on the property per the site plan. Most of the equipment that's being stored on the property is in harmony with the equipment that can be found in an agriculture zoning district. So with that, staff is recommending approval of conditional use permit CU 22-47 with conditions.
Thank you, Cody. Questions for Cody?
If I remember rightly, this is the old Simpkins place. This is kind of in the middle of no place. I can't imagine where this would hurt a thing. But I do have a question under the analysis. You, on C, have most of the equipment. Does that mean some's not right, or?
Staff didn't just want to generalize. I mean, not every agriculture district has a backhoe on it, but you can find backhoes on agriculture properties, on farms and ranches and stuff.
Okay. All right, well, that's it, yep.
Any other questions for Cody? Does your applicant care to speak, or are they here? I didn't have any. Okay. It's fine. Chair to address a motion.
Mr. Chair, I would move approval of conditional use 22-47.
Second.
Moved and seconded to approve conditional use permit CU 22-47. I believe it's with 14 conditions per staff's recommendation. Discussion from the audience. Does anyone care to speak before we address the motion? From the commission? Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. On to item number 11.
Mr. Chair, I would make a motion that we combine 11 and 12 for discussion purposes. However, we will vote on them separately.
Is there a second to that motion?
Second.
Moved and seconded to combine for discussion purposes, agenda item number 11 and number 12, and it is understood that they will be separated after discussion to handle action individually. Any discussion on that motion from the audience, from the commission? Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. You may go ahead and address 11 and 12 together.
Okay, so item 11 is comprehensive plan amendment CA 22-20. It is to amend the comprehensive plan to change the future land use from agriculture district to ranchette district. And item number 12 is rezone RZ 22-27 to rezone 14.17 acres from agriculture district to ranchette district. The applicant and landowner is Brian Schroeder. The agent is Davis Engineering. Location of the property is 24075 Barney Road. It involves 14.17 acres. Current zoning is agriculture district. The existing land use is vacant. Access is off Barney Road and there is no special flood hazard area on the property. The applicant is currently going through the layout plan with the planning and zoning office. Upon review of that layout plan, it was determined that this lot is on a dead-end road system. So there's some additional items that the applicant would have to take care of to move forward in the plating process. So staff wasn't comfortable rezoning and changing the comprehensive plan until those items are worked out with some subdivision regulation variances. So staff is recommending to continue comprehensive plan amendment CA 22-20 and rezone RZ 22-27 to the December 12th, 2022 planning commission meeting to allow the applicant time to apply and obtain approved subdivision regulation variance for increased lots on a dead-end road system.
Thank you, Cody. Questions for Cody?
Mr. Chair. Cody, I see some GIS maps in here, but I don't see a location map that kind of shows the general proximity where this property is. I know it's in 1-7, and so it's got to be south of Rapid City, but I'm not sure where this particular.
So it's off of Neck Yoke Road and Heart Ranch Road West. It's at the very, very end of the road.
Just south of that neck.
Okay.
Yeah. So this is the subject property.
Yep, okay, now I know where you're at. I just didn't, looking at this, I had a hard time trying to figure out where that was at.
Any other questions for Cody? We do have speaker request form on this. Shane Taylor? Come right up, introduce yourself just for the record, Shane, and take off where you'd like to go.
How are you guys? I'm the current president of the Knotty Pine Road District. I'm ill prepared for this conversation. I just found out Thursday that this was going on. I think what happened, Cody, was the gentleman that brought it to my attention is John Olson, our past president, and I think the letter you were talking about probably went to him instead of me, but we'll get that figured out. But you guys see the map up there.
Can I interrupt you just for a moment, and so that you understand we're discussing both at the same time?
Cody,
I don't
yes.
want to be that you feel you got to come up again. We are discussing both at the same time. You may address both.
Okay.
Thank you.
That's good. What I'm trying to bring to your guys' attention is that is a dead-end road, and Barney Road there that they're talking about, we as a road district do not have the funding to improve that road like it needs to be improved. The past president and the secretary actually got the School of Mines to come out there and kind of give us a recommendation how to maintain it. On Barney Road there's two very deep, it's really a single road going back into the residents that are back there. There's two real steep ravines that they went over that. They're extremely narrow. And it's kind of funny, you guys, the recommendation was to put a railing in there, so cars don't slide off of those. And the recommendation was to use 2x6s with posts, It's not going to stop the propane truck, the UPS truck, or anything from going off the edge there. So I, as president, am very reluctant to spend any money on that. The problem when the road was put in there, the deeper ravines, when I've been over there investigating this, it's all filled in with car bodies. There's no way you can dig post holes under this stuff enough to support anything or put a railing in there, but the road is extremely narrow. And another thing that's been brought to my attention just in the last couple of days is it is a dead-end road back there. The forest has never been, what am I trying to say, maintained or anything. There's tremendous concern of wildfire back there, and there's no way residents are going to be able to get out of there. Fire trucks are going to be able to get in there if we really do have a wildfire situation. But I guess me as president of the road district, if we're going to start developing back in there, which is fine, but we need help. I don't know if that comes from the county, the developers, or whatever, but that road needs to be improved. The road district does not have the funds to improve the road like it needs to be. We've got drainage issues. It literally is a single track road in and out of there. And with those big ravines, there's hazards there, big hazards for traffic going back and forth out of traffic. And so I really appreciate Cody bringing it to my attention this morning that you guys are, there's a lot more to be considered before anything's decided on this. And I spoke with my secretary and others that are involved, and I think she's preparing a letter too, but it's my understanding that there's going to be another meeting on November 1st, but this is going to be continued for a 12 date before you guys make a decision on it.
That's correct, December 12th. I see. The continuation recommendation is for December 12th.
Yeah, okay, I'll let everybody know, people that have concerns, but we need help on Barney Road. I don't know if it comes from the developer, the county, I just stepped in here this morning but before I would, that just really needs to be addressed before we start developing property back there.
Mr. Chair.
Yeah. Questions for Mr. Taylor or comments?
Yes, relative to, the county participating in Barney Road, what we can do for road districts is that we can sell you gravel at the county's cost. And I don't know if that's deliberate or not. I'm guessing it's probably not. But we've run into this with other road districts, and you're one of many that have really poor roads. And as far as our highway superintendent's concerned and the way that we're set up as a county, we can certainly help by trying to ease the cost of the aggregate that you're going to need probably to get Barney Road in fairly decent shape.
With gravel, you mean, at cost?
Right. Another thing I'd like, Cody, could you expand that a little bit and put a zoning overlay so we can just see what that whole general area is zoned? And so if they were to rezone to rural or ranchette district, what color would that be?
It would be, sorry, Cody Sack, environmental planner. It would be tan color, sorry.
Tan.
So it'd be out there by itself then, wouldn't it?
It would, yes. Whether staff would support it or not. So staff, once we were going through the layout plan and noticed it was a dead-end road system, our review pretty much stops at that point until things are done. I wouldn't necessarily say staff would support it, but I wouldn't say staff wouldn't support it. It's going down, it's a 14-acre property that they're subdividing. They wouldn't be able to subdivide anymore after that. They'd only still be able to do just the 2 lots that he's proposing, and you can make the argument for ranch out there. To address the comments of the road, that's done through the platting process. So one thing he has to do is he has to dedicate more right-of-way. It requires a 66-foot wide right-of-way. So he has to dedicate more right-of-way on his property. And then he has to construct a 24-foot wide road or obtain a variance through the Board of Commissioners not to build a 24-foot wide road for Barney Road on that property.
So say that again so I understand.
and I can talk to you after the
Okay, I'll talk to Cody after that because yeah.
But just for the information for the planning commission.
Any other questions or comments for Mr. Taylor?
No, I appreciate him coming and speaking with us today so we can get information that we would normally not get unless we actually went out there to the site. Yeah.
Okay,
which
and
I still might do.
there is help for road districts. I live on a dead-end road district. You're gonna wanna speak to the auditor's office. They can give you some instructions, but depending on your membership, in other words, how extensive it goes out into the other plattings. And I don't know that, and you would, who your members are. They are receiving a
We have
unincorporated
40
road.
members in our road district.
You do have 40.
Yeah.
Okay, they are receiving an unincorporated road tax deduction from their property taxes. Each property receives this, and it's based upon a mill levy, which the auditor's office or the equalization, you actually need their help, but you go over and get it from the equalization, and that will tell you how much savings in taxes each one of those property owners receives, as well as your entire road district for the year. And that is a savings that can be applied, as well as whatever your rules and rights. We can't advise you on your rules and rights as a road district, but there are some in regards to additional new members.
Who do Cody can help me with that.
Yeah.
Yeah, okay. Thank you for your input.
Yeah, Shane.
Charlie.
Thank you very much for coming forward and explaining your situation to us.
Okay, thank you, guys.
Thank you.
Anyone else from the audience who would like to speak on this matter? Chair to address a motion based upon the staff's recommendation.
I would move to continue CA 22-20 to the December 12th meeting per staff's recommendation.
All right, is there a second to that motion? Okay, it's been moved and seconded to continue CA 2220 Comprehensive Plan Amendment per staff's recommendation to the December 12th, 2022 Planning Commission meeting. Discussion. Hearing none, all in favor of the motion signify by saying aye.
Aye.
Those opposed? Motion carried. We do need to take care of item number 12.
Mr. Chair, I will move to continue rezone RZ 22-27 until December the 12th, 2022.
Okay, second to that.
Second.
Moved and seconded to continue rezone RZ 22-27 per staff's recommendation to the December 12th, 2022 Planning Commission meeting. Discussion. Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. On to item number 13.
Item number, Cody Sack, environmental planner. Item 13 is minor plat MPL 22-52. It's to subdivide and create lots 2A and 2B, block 2 of Thoson subdivision. The applicant is Lynn Hanson. The surveyor is All Aspects Incorporated. Location of the property is 13655 Highway 40. It's currently zoned agriculture district with an existing land use of residential. Access is off Highway 40, and there is special flood hazard area on the property. Currently on the property, there's a double-wide mobile home and a equipment building. All were placed prior to the requirement of building permits. And then there is 2 septic systems on the property that were placed on the property in 2021. For the proposed lot 2A will be 20.53 acres. And then lot B will be 31.81 acres. And I actually believe this is mixed up. Lot 2B will have the double-wide mobile home on the property with the equipment building and the septic system. This was routed off for interdepartmental review. Register of Deeds had some comments. The plat heading needs to have formally be Lot 2 revised of Block 2 Thoson subdivision. And then there were some issues with the certificates. I believe those issues have been taken care of. The applicant is proposing to subdivide the property into 2 separate parcels. On September 29th, 2022, staff approved layout plan LPO 22-47 with conditions. At the time of the staff report, all conditions appeared to be met except for conditions 4 and 6. I believe that has been fixed by the surveyor. The applicant has also applied for a conditional use permit CU 22-45 to allow a recreational vehicle on proposed Lot 1, once the plating process is complete, and that will be heard on the next agenda item. Staff has no significant issues with the applicant's request as it appears to be in harmony with existing lots and current land uses in the area. So staff is recommending approval of minor plat MPL 22-52 with conditions.
Thank you, Cody. Questions for Cody on?
Cody, I don't know which is which at this point, but proposed lots B, I guess is A now. Are there 2 septic tanks on that one?
So there'll be one septic tank on each of the properties. There's one on, this has the proposed lot 2B that has the double wide mobile home, and then the other one, on lot 2A has that had the applicants applying for that conditional use permit. There's another one for that recreational vehicle.
Has that been used before, or is that something that's fairly new?
They were placed on the property in 2021, early 2022.
Never been used then?
I don't know. I'm guessing the one in the double wide has been.
Well, yeah.
But the one for the mobile or the RV, I'm not sure of if it's been used or not.
Other questions for Cody? I don't have any speaker for him, but is someone in the audience here to speak on this or not? Okay. Additional discussion? Chair is ready for a motion.
Mr. Chair, I'll go ahead and approve minor plat MPL 22-52.
Second. Moved and seconded to approve minor plat MPL 22-52 per staff's recommendation. I believe it has 6 conditions. Discussion from the audience, from the commission. Hearing none, all in favor of the motion signify by saying aye.
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 Opposed? Motion carried. On to item number 14.
Morning again, Commissioners. Jason Fennis, Assistant Planning Director. Agenda item number 14 is conditional use permit 22-45 to allow an efficiency dwelling on the subject property. Applicant is Lynn Hanson. Location of the property is 13655 Highway 40. It is currently 52.61 acres, but as you heard, it is planned to be subdivided. It's currently zoned agriculture district. Access is off Highway 40, and there is special flood hazard area on the property. Zoning ordinance lists 7 criteria the Planning Commission may consider in their review of conditional use permit applications. I'll read staff's responses. Apologize for not having those on the screen for you. Number 1, no, the requested use should not be detrimental or endanger the public health, safety, or general welfare of the public. Placement of the efficiency dwelling is on a secluded piece of the subject property. Number 2, no, the requested use should not be substantially impair or diminish the uses, values, or enjoyment of other property in the neighborhood for purposes already permitted. Number 3, no, the requested use should not impede the normal orderly development and improvement of the surrounding properties for uses permitted in the district. And number 4, yes, an address will be assigned to the efficiency dwelling and posted in accordance with Pennington County Ordinance number 20. Access is off of a well-maintained gravel driveway from Highway 40. And an existing permitted on-site wastewater treatment system will provide a means of wastewater disposal. Number 5, yes, the existing approach will provide ingress and egress to minimize traffic congestion on Highway 40. Number 6, yes, the current zoning district is agriculture district. The requested use will conform to the applicable regulations in the district if this conditional use permit is approved. And lastly, number 7, future land use is identified as agriculture district. The requested use is consistent within this district with an approved CUP. Staff did review Pennington County zoning ordinance section 330, which lists the criteria that must be followed to allow an efficiency dwelling, and found that the proposed efficiency dwelling does meet those requirements. Property history, there is a double-wide mobile home placed in 1994, an equipment building, an accessory structure, as well as 2 on-site wastewater construction permits that were placed in 2021, and an on-site wastewater treatment system for the double-wide mobile home. The request was sent out for interdepartmental review, and the only comment that came back was from the addressing coordinator stating that there must be an address assigned to the efficiency dwelling if it's approved. Staff's analysis of the request. The applicant is requesting to use the use of an efficiency dwelling on the subject property. The request is currently a use by right in a subject property, on the subject property, because it is currently over 40 acres taxed and zoned agriculture district. So he's coming in because he is subdividing that property to lesser than 40 acres. The efficiency dwelling will have a residential appearance. It will be a Four Seasons pull-type recreational vehicle that will be converted to a park model RV. It will be permanently anchored to the ground with the wheels removed. It will have skirting and an attached deck. It is a 8 by 36 foot, 288 square foot RV with the bump outs. It does reach a maximum square footage of 398.5. And here's a floor plan of that RV. Do also have some pictures from a site visit. So this is the placement of the structure or of the RV prior to conversion. Like I said, you will have skirting. You will remove the wheels and tires and permanently anchor it to the ground, so it'll have more of a residential appearance. There's only one neighbor that could potentially see this, and we do have a letter of support from that neighbor, and that's these folks here. It will be on 20.53 acres, so it will be relatively secluded. The proposed conversion appears to qualify this unit as a park model RV. Pennington County zoning ordinance section 330 states that park models on a permanent foundation are allowed as efficiency dwellings if the structure meets this section. With that, staff recommends approval of conditional use permit 22-45 with conditions.
Thank you, Jason. Questions for Jason? I don't mind starting out, Jason. You brought in the big guns for this, so. The 20 acres is not, we talked about that. 20 acres is not my objection in the site and whatnot. It's the precedent we're setting. On page 200 of the ordinances, and that's the latest issue, July 20th, 2022 that I have, it says accessory dwelling, and down it says not a recreational vehicle. The next item that I have that I question is that a recreational vehicle has a title. I think you're going to have some problems with the tax people on how they establish an amount that's owed and what's not. Once you take the wheels off it, is the value then zero? It has a book value based on title. And then the third thing would be, and by the way, and when I say RV, it's purpose-built as an RV. So we're deciding that we're going to change this purpose. And then finally, an accessory structure, and you and I know what's coming down the pike for the vacation home rental, is going to be an allowable structure for vacation home rental down the road. And now we've sent out condition after condition that says an RV cannot be a vacation home rental. We've done this again and again and again. And here we are looking at approving one because nobody sees it. I think the precedent here is just terrible.
Like we discussed upstairs, I think an important
Go
thing to
ahead,
note
Jason.
is that a park model is an RV. A park model is titled the same as an RV. It meets the same safety standards as an RV. So that's how I was able to recommend approval on this, is that it meets those requirements. We allow efficiency dwellings to be park model RVs. Now, how that's handled with equalization, I'm not sure.
Why
But they
are we
would have
even
to be-
calling it an efficiency? It's an accessory dwelling, isn't it?
No, it's an efficiency dwelling.
Okay, like our small houses?
Well, it's a totally
What
different-
people used to,
It's a totally different section of the ordinance. So there's accessory dwelling units, and then there's efficiency dwellings.
what are we referring to that I missed? It appears this is an accessory type of dwelling, isn't it?
Efficiency dwelling. So
Okay.
it's covered under a different section of the zoning ordinance.
Can you help me?
330.
Megan Krieger with the State's
Go right
Attorney's
ahead.
Office. I think the confusion is that this property is going to be subdivided, so it's not going to be an accessory structure. It's going to be the primary use on that property, the only use on that property. That's why it falls under our tiny home. It's not an accessory structure because there is no other structure on the property once it's platted, so,
Okay,
makes
I
sense?
understand what you're
Yeah.
saying. If that's the case, I can't remember ever approving one for longer than 180 days, usually any year.
Right, and I spoke with the applicant about that. I asked him if it's going to be a temporary use while he builds a future home, and he said it wouldn't be. So he asked about the efficiency dwelling and if we could go that route. So that's why we're here today. And
Well, we're allowing the efficiency
And-
dwelling too to be, in certain conditions, to be looked at as a vacation home rental.
so, yeah, and to address that, that was your third
Sure.
thing you brought up. So I don't think the applicant would be opposed to having an additional condition of approval in there that he would not use it as a vacation home rental. Those are not his plans. I do not think that he would object to that at all.
Okay, let me go down. It says, will the proposed efficiency dwelling have a residential appearance? You put yes. How can you say yes when it's meant to back up underneath a pickup?
He does plan to put skirting on it. Like, this is as it sat there during the site visit.
Okay.
There was nothing out there. You know, I did word those conditions of approval that prior to operation that he would have those things done, including removing the wheels and permanently anchoring it to the ground.
Which one of the living rooms has got to have 120 feet or 200? Are we falling into with this one?
It's got a separate bedroom, so we would fall under,
Okay.
and we have denied this sort of thing in other zoning districts. Those were higher density, rural residential, and they were proposing to use it as a vacation home rental. So that was the reason that one was denied.
All right, and I have no basis other than experience on this one, and you and I talked about it. Because I've personally done both, but just if you took a modular home versus a mobile home and tried to put it on a permanent foundation, I guarantee you the mobile home is an exciting challenge to do compared to the modular home because of the construction of it. And we're talking about taking a unit here that's meant to drag down the road, and we're going to put it on what we call a permanent foundation. You know, I say, what is a permanent foundation under this? I mean, that's going to be are we just going to put piers? Are we going to put screw in the ground things and then throw them into concrete? What are we going to do?
So that's what we looked at for mobile homes. We
Okay.
require anchoring in the same. So we don't require them to remove the entire chassis and put it on a permanent foundation. We just require that it's anchored to the ground. So that's kind of the same mindset I applied here, is that he would put straps on it, permanently anchor it to the ground, remove the wheels.
And even a different frame than this. You know what I'm saying? A mobile home's a considerable different frame than this. I just don't see it. I think we're setting the wrong precedent putting a mobile home, whether it's 20 acres and out of sight, and it may be, I don't know, I haven't been there. I don't get the book early enough to drive up and look at all these anymore, so. Any other questions for Jason?
My only concern at this point is it's almost a license to kill if we okay something like this for the future. It's a little spooky, I would think.
I believe it's a case-by-case basis for conditional use permits. I don't
Yeah.
think that you necessarily set a precedent by approving it, but
It's
that's
hard
just
to
my
say
opinion.
no to somebody and yes to somebody else, and somebody says, what's the difference? But if this is what it is, it's what it is.
Thank you. Does the applicant here want to speak?
He was supposed to be here. I think something must have come up, but he's not here.
Okay. Well,
Mr. Chair.
yes.
I think you're going to see more of this in the future. I don't think they're going to get rubber stamped, but this is just a way to address the housing shortage and the cost to build a house nowadays. And this is an alternative. And I see a lot of people trying to live in campers nowadays. And the hospital, they rent campers down there by Hart Branch for their staff that travels. And so I see it as a trend. We just have to be, each one's got to be treated differently, that's all.
Thank you. I want to throw in one more comment. When I look at the picture of this, and then I look at the pictures of what I've looked at on other projects for the efficiency dwelling, and I think of the one father and daughter thing that went through a lot of hoops over an address on an efficiency dwelling. This does not look like an efficiency dwelling, or like alongside the road on 16 that we approved the court for. We did just do a court for some of these, didn't we? Under, like, it's a national franchise
It's
type of
actually
thing.
the first conditional use permit we've heard for an efficiency dwelling.
No, but I think we did a court across from RB that allows efficiency dwellings in that place. I believe we did. In
That's
fact,
how
they're
it
doing
runs.
the
So that
dirt
was-
work over there.
So that was a planned unit development.
Yeah, but it was efficiency. What I'm getting at is that's where my hangup is at. That to me does not look like an efficiency dwelling, irregardless of what you're saying the building requirements are. It just doesn't look like a small house or something that people should be moving into the future. It looks like something you drag coming through, and you buy some property, or you make a deal and you lease some property and you put it down, and then you move. You know, it's just, I think it's a wrong direction to head, that's what we want to do as a county.
And I want to point out, this is prior to the improvements that he plans to make to it as well, with the skirting to make it
Sure.
have more of a residential
Sure it is.
appearance.
Thank you for that.
Mr. Chair,
Yes.
I share the chairman's frustration with this, with just the appearance of this, but it just seems to me it's a single wide trailer that's got bump outs and probably built much better than the average single wide in existence. And I tend to agree that we're going to see more of this, and if people, we need to monitor concerns about safety and efficiency up to a point, but that I think our province is somewhat limited, and it sounds to me like this technically meets the compelling definitions of an efficiency dwelling. I wouldn't want to live in it particularly myself, but there may be a time in which I'd have to. So it would be good to have it. I don't know. But I understand the chairman's frustration, and but I would be willing to support it, I think, in spite of that.
Any other discussion? Hearing none, the chair is ready for a motion.
Chair?
Yes.
I would move to approve conditional use permit CU 22-45 with this 13 conditions.
Is there a second?
Second.
Moved and seconded to approve CU 22-45 with 13 conditions. Any discussion? Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Aye.
Aye.
Two of us, I guess. Be 5-2, Jerry.
I was a no also.
You were an objection to 4-3. Okay, it's passed 4-3. Okay, on to item number 15. Jason, give us a second here to do a little housework.
Sure.
Before we start.
I'll be abstaining from voting on this matter.
Okay,
Mr. Chair, as I will too, as I'm the president of Blue Wing Recreation Corporation, and I will stand for any questions and maybe offer a brief history of how we got here today.
all right. That's what I wanted to clean up for housekeeping. Commissioner Roskinick did come to me at the previous meeting before it was continued, and in this meeting he is going to abstain, and Kevin now is abstaining. We have to announce these things at the start. But Mr. Roskinick, Commissioner Roskinick also stated that he wanted to speak on the matter, and I don't see that in any way contrary to Robert's Rules of Order. What I did ask of him, and he's in agreement with, and I've done this before in meetings a long time ago, but as an abstaining member, and I'll read these to you so you understand, Commission, what we're talking about. Member will be allowed to speak as to historical information and/or factual data on the agenda item and will be allowed to ask or answer questions from the commission, staff, Pennington County officials, from the public, while remaining seated as commissioner. Number two, however, when the planning commission has formulated a motion and the motion has been seconded, should the abstaining commissioner desire to participate in discussion on the action, either in support of or opposition, the abstaining commissioner will be asked to do so from the public area so that there is no confusion as to that he's speaking as a private individual or an agent on the matter, not as a commissioner. Now, as the commission, you have a right to discuss that ruling. That's the ruling I've made with Mr. Roskinek, Commissioner Roskinek. If you do, any of you have take exception to that, if there's two of you, then we have to vote on it. Okay? Then it's going to stand. That is the ruling I made with Commissioner Roskinek. He's satisfied with that ruling. Let's go ahead with item number 15.
Agenda item number 15 is Major Planned Unit Development Amendment 22-13 to amend the existing Blue Wing Planned Unit Development to reduce the required building setback to Blue Wing Road from 10 feet to 5 feet. Applicant is Blue Wing Recreation Corporation. The agent is Ron Roskinek. Location is north of Calumet Road, south of Sheridan Lake. It is 67.12 acres, zoned planned unit development. Existing land use is Blue Wing Resort. Access is off Blue Wing Road, and there is special flood hazard area on the property. Planning Commission did approve minor planned unit development amendment 21-13 in October of last year. The request was sent out for interdepartmental review. County Fire Administrator did note that reduction of setbacks is a bad idea. It affects the size of apparatus responding and spacing to buildings and improvements, just to name a few. And I did capture some of that in my analysis. Just to go through that briefly, the applicant originally requested to reduce setbacks to all interior roads from 10 feet to 5 feet in order to bring existing structures into compliance. On September 26th of this year, the Planning Commission continued minor planned unit development amendment 2213 to this meeting in order to allow the applicant time to revise his request. The applicant is now requesting that the reduced setbacks 10 feet to 5 feet only apply to Blue Wing Road, which is the main road through Blue Wing. I apologize, I don't have a good aerial photo, but Blue Wing is here. It is paved. It runs more or less the entire length of the PUD. So with that, staff did change condition number 6 to read that the setbacks for all future recreation sites and structures be a minimum of 20 feet between units, 5 feet from Blue Wing Road, 10 feet from all other access roads, 0 feet from lot line, interior lot lines, and 25 feet from exterior lot lines, and 58 feet from existing and relocated section lines. With that, staff finds no significant issues with the applicant's request, as it appears to be in harmony with existing lots and current land uses in the area. And staff recommends approval of Major Planned Unit Development Amendment 2213 with conditions.
Thank you, Jason. Is there questions for Jason other than the applicant?
None here, but it'd be more.
Okay, I do have a question for you, Jason. Did the fire administrator send any revised comments, or?
No, he did not revise any comments.
Okay, thank you. Any other questions for Jason? You
Mr.
have
Chair,
the floor as the applicant.
Just a brief history. If you look at that whole area, those are mining mineral surveys that were established back in the late 1800s, and it was called the Calumet copper mine. And in the 30s, the federal government come in and they purchased what they thought was enough land to develop Sheridan Lake as it sits today. What they didn't do is they should have probably purchased this when they were doing that back in the 30s, because we're pretty close to the lake. So in this around 65, our folks bought this, and I put pictures in there which would show you kind of what it looked like in 65. And that Blue Wing Road was a wagon trail to haul lumber for Warren Lamb Lumber, which supplied lumber to a lot of the sawmills for They supplied lumber to the sawmills, which then supplied for the mining operations that were going on in that area back in that time frame. But Blue Wing is a seasonal recreational resort, and we're open 5 months a year, and then we're shut down. And if you look at Blue Wing, what we offer would be really similar to what the Caraway at Mount Rushmore offers. When we improved the wagon trail, a lot of these places were probably 10 feet off. But when we did the paving, it's a 16-foot paved surface that brought some of those into an encroachment status, and that's what we're trying to fix today. Something that was there since 1965. In 2000, Marcia Elkins, who was the planning and zoning director for Pennington County, called me up and said, "You have to do something here because we weren't zoned." And so I did the rezone with her and Scott Anderson. It took me about a year to do it. I got a binder that's 3 inches thick. But these places were there in 2000 when we did the rezone to what is now the current plan unit development. And if anybody's got any questions, I'd be more than happy to answer them.
Okay, questions for the applicant from the staff?
No, sir.
Anyone from the audience would like to question the applicant? Thank you. Well, commission certainly can ask questions of either the applicant or the staff. Any questions for them on this? This is the revised submission then based upon our conversation at the original one.
Correct.
It appears to me, and I can understand that, and it does appear to be worded right, so it fits the particular location that's in problem. Now, I guess I would have liked to have the fire administrator, is that is correct title? Fire administrator come up with revised comments, and it may only include this because that, as the applicant pointed out, this condition exists throughout the entire development. So, any other comments or questions? Hearing none, the chair would address a motion.
I move that we approve PU 22-13.
Is there a second?
Second.
Moved and seconded to approve PU 22-13, and I assume the same conditions exist and remain, and that would be 9 of them per staff's recommendation. Discussion. We do have 2 members that are abstaining. Kevin and Ron are both abstaining in the vote, so the record needs to show that. Trey. Any other discussion? Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. Now, we're on to item number 16.
Agenda item number 16 is conditional use permit revocation 71-04 to revoke the use of an existing mobile home park on the subject property. The applicant is David Allard. The location of the property is 12350 West Highway 44. It is currently 3.11 acres, zoned commercial district. Use is residential. Access is off West Highway 44, and there is special flood hazard area on the property to include the 100-year special flood hazard area and floodway. Planning Commission last approved the extension of conditional use permit 71-04 on December 21st of 2020. There are 5 conditions that are not being met at this time, and I'll detail those in my analysis. As it sits, the property has 7 different lots on it for mobile homes. Lot 1 contains a 14 by 57 single-wide mobile home, a carport, and a shed. The carport has a permit, but it has not been approved because it is in the special flood hazard area. Lot 2 has a 14 by 70 single-wide mobile home on it. It has a permit. It does have a carport without a permit. Lot 3 has a 14 by 67 single-wide mobile home that appears to have been installed prior to 1994 with a non-permitted carport and a shed. Lot 4 has a 16 by 80 single-wide mobile home with a permit. It also has a carport with no permit and a shed. Lot 5 has a 14 by 67 foot single-wide mobile home that appears to have been installed prior to 1994. Also has an unpermitted carport and a shed. Lot 6 has a 14 by 70 single-wide mobile home with a permit. a carport with no permit, and a shed. And lastly, Lot 7 has a 14 by 75-foot single-wide mobile home constructed prior to 1994 per Department of Equalization records, has a 10 by 14 permitted deck addition, an attached garage built prior to 1994, a shed built prior to 1994, and a shed with a garage door with a permit, and a carport with no permit. There are 3 on-site wastewater treatment systems on the property, and they all 3 have operating permits. There are also 3 floodplain development permits on the property, as well as 3 ordinance violations. The most recent was opened in January of 2020. It's COVO 20-005. Staff did send the first notice to the applicant, David Allard, explaining that the applicant, that he has structures on the property without proper permitting. And I do have more history in here. I did include that in the packet, so I don't really want to go through all of that. I'll just skip to the analysis if that's all right with you guys. So the analysis, I'll just detail the conditions that aren't being met. Condition number 2, and I'll put those on the screen. So hopefully you can read those. I'll start with condition number 2. There's an unpermitted carport located on Lot 1 that is located within the 100-year FEMA designated floodway. And that's this carport here. These photos here were taken by Department of Equalization. Looks like November of 2021. So a little history on that is November 30th, 2020, the applicant applied for a building permit to place a 12 by 12 carport on Lot 1. On December 11th that year, upon staff review, the location of the existing carport could not be accurately determined in relation to the FEMA designated flood boundaries. So give you an idea what I'm talking about. So this is Lot 1. This is the existing carport that he applied a permit for. So this was his site plan that he submitted to us. The floodplain development permit study, which is shown here, there's definitely a discrepancy. I couldn't tell where that carport is in relation to any of the other structures identified on this survey. So I'll flip back to this one. Pad 4, I believe, is this pad here, but I can't see. So these 3 structures, A, B, and C, were for sheds, and that's why he applied for this floodplain development permit, one for each one of these. I asked him to update the site plan, either this survey or a separate floodplain development permit, met with negative response. So on to conditions 3, 5, and 8 that are not being met. According to the Department of Equalization, the applicant remodeled the storage area of the attached garage and created living quarters. So this is the single wide mobile home if you're looking straight at it. This is an attached garage. It has 3 stalls on this side and 3 stalls on the back side. So again, these are pictures from Department of Equalization. The one on the left is from 2017. You can note the windows here. And then on the right-hand side, you can see from September 14th of 2021, some definite remodeling has happened. They've added windows. On August 2nd of 2022, an administrative hearing was held by the South Dakota Office of Hearing Examiners in Pierre, South Dakota, which included the following in the hearing order. And I noted what they said in their transcript. It said the previously designated attached mobile home is designated a stick-built residence and is properly placed on tax ID. So meaning that they have to place that on tax ID as a stick-built residence. So with that, essentially they're saying this is its own separate residence. So the stick-built residence is attached to the mobile home and meets the definition of a multiple family dwelling. Therefore, a conditional use permit is required in a commercial zoning district. So the applicant would have the choice to come in and apply for a separate conditional use permit for this multiple family dwelling, or possibly apply for a planned unit development overlay district to allow this use, but it is not currently allowed in the conditional use permit as it's written. Also, any unfinished space within the stick-built residence that was converted to finished space will require approved building permits. We've not received any building permits for any of the work that's been done there. also penalty fees would go along with those because the work's already been done. So condition number 9, the ordinance enforcement officer reported seven separate contacts with owners, or with the owner regarding county violation 20-005 since December 21st of 2020. Since the last review of conditional use permit 71-04, no action has been taken by the applicant to obtain building permits for the carports. And with that, staff recommends to end conditional use permit 71-04.
Thank you, Jason. Questions for Jason?
Mr. Chair, Mr. Chair, relative, when they say relative to the carports, when they say permanently, now I'm putting my appraiser hat on because for 30 years I've been a South Dakota State Certified General Appraiser. And in those 30 years, I've never considered a carport real estate. That's just the way I do business. I'm not saying that's, and when they say permanently, in the appraisal business, we mean you're going to have a concrete footing, you're going to have a bolt come up, and you're going to permanently attach that down so that it cannot be moved. But if it's not and when they say permanently, that's trying to figure out what permanently is, because to me it's very subjective. This is where I have, when I see permanently, what is permanently? Is there a definition that the county uses?
So regardless of that definition, there is a condition of approval, condition number 9, that was approved by the Planning Commission that states that all carports on the subject property be anchored and permanently affixed to the ground and building permits be attained. I think that was due to a safety issue that was brought up with one of these blowing over in the wind. So I believe that's why the Planning Commission heard that as a condition of approval at their last review.
Any other questions for Jason? Jason, I've got one. And maybe I'm being my usual picky self, but if you looked at criteria reviewed number 8, and then you look at the over here, it'd be C, D, and E under the conditions 3, 5, and 8. It's kind of vague, number 8 versus, because this is quite an in-depth process for C, D, and E. In other words, it's like a double jeopardy. On the top, we're saying he didn't meet these other conditions, but this is a new one and a rather extensive one is what I'm suggesting, whether we should be listing that as a separate
You're talking
item.
about condition number 8 specifically?
Yeah, somehow so that it's spelled out, and in other words, it's all falling under one roof for him, so that him or his representative, so they can look at it.
Right.
We're not coming in later and say you didn't meet this one, so now we can start on this one, because I know that C, D, and E are very extensive to approach.
Right.
Is
So
that a good
so
word?
you're right, that is more or less a blanket condition of approval. But
Right.
it was one that's not being met due to the other ones not being met.
I just wanted to get them all under one roof if we're going to address them, and the applicant's going to be here, the department's going to be here, and the commission's sitting and going to review these things. So that would be a suggestion to clarify that somewhat. Any other questions for Jason?
Mr. Chair,
Go ahead.
if we go ahead and approve this revocation of CU 71-04, my concern is that this is my district and some of the tenants could be displaced. And I'd like to see if we could work something out with a motion that these folks have time to relocate, because this isn't the time of year. Most of them have limited income to have to go out and find another place to live. I've seen this happen in Rapid City, and it's not pretty.
Point well taken. The applicant's here?
They are, or he
Okay.
is. I believe he
Does
is.
the applicant care to speak? I see I do have a speaker request form that you have a representative that was going to speak. Okay. Kimberly? Would you introduce yourself just for the record, please, and then go on from there?
Yes, thank you. My name is Kim Pearson, and I'm an attorney representing David Allard. I spoke recently with Megan at the State's Attorney's Office and Jason at Planning and Zoning and Dwayne at Code Enforcement. And we discussed the options that my client would have related to conditions 2, 3, and 9, which were the 3 conditions that he was advised or he was not meeting, and how we can avoid the revocation of this conditional use permit. As the commissioner noted, there are 10 people who live out there and who would have to find somewhere else to live all of a sudden if this were to be, this 50-year-old conditional use permit were revoked. Based on the discussion that I had with the officials, it was suggested, since there was more than one way that we could resolve this issue, it was suggested that this hearing could be continued so that we could work towards resolving the issues and avoid the revocation and avoid displacing individuals. So I came today because I was concerned when I read the staff report on Friday afternoon that there's nothing in there about continuing this after we had a discussion that it would be continued. We are asking, Mr. Allard, that this be continued to a future date because I believe there's been some breakdown in communication between Mr. Allard and the departments as to what needs to happen and why it needs to happen. I'm hopeful that with my involvement, we can resolve some of these issues in a manner that's not going to displace 10 Pennington County residents when it's already hard to find affordable housing. I'm also concerned that in this staff report, there's 2 additional conditions listed as violations that were not provided to my client in the notice of revocation. And that is a due process concern for my client, that this could be revoked when he wasn't notified that he was violating some of those conditions, numbers 5 and 8. I can certainly argue against why this should not be revoked, but if the commission is inclined to continue this so that we can try and work towards a resolution, I would rather that be the outcome than me stand here and argue for quite a while if the commission is more inclined to continue the matter.
Thank you, Kimberly. I do have one question right up front, and I'm sure it's on the mind would your applicant, you and the applicant, be interested then if we were to consider a continuation of pinning down the follow-up dates for those sort of things, that the assumption is we cannot schedule, I can't say you got dates 6 times in a row. We have to do them one time, and then we follow up from there. So what I'm suggesting is, maybe rightly and wrongly, so I don't think we're going to have this done in one continuation. Would you continue to accept a date type stance for follow-up?
Yes, if you want to put a condition that we need to have met and done.
Or resolved. Is
resolve,
that a way?
Resolve the issue by a certain date, and then we would come back. That's perfectly appropriate.
Any other questions for Kimberly from the commission? Do you understand what I was suggesting there? We're limited as our continuations. They have to be specified by date, and we can't specify by date at this time for multiple dates. That's what I was trying to concur. Go ahead. Any questions for Kimberly while she's up here?
I guess it's not a question really. I would be willing to vote for continuance as long as there was progress made toward resolving all these issues.
Yes, and that is certainly my intent, is to resolve this issue so that we don't have 10 people.
Jason, can you come up real quick?
Yeah, we need Jason back up, don't we?
So Jason, if we go this route, and I'm in favor of a continuance too, I don't want to see people displaced. So your office would be more than happy to work with Dave, and we'll set some hard dates that things got to be done. And then if they're not, they're not. It'll make this decision a lot easier, though, if we allow some additional time to get some of these issues rectified.
We've been willing for the last almost 2 years to work with the applicant.
Understand?
Okay, any other questions for Kimberly or Jason?
Mr. Chairman. Yeah, I noticed this has been going on almost 3 years. And it seems like many of the fixes are relatively minor. This is not rocket science, or nor does it take large capital investments to solve these problems. I think it's regretful that he's using Mr. Roskinek's constituents as, hostages, basically. And I hate to see that kind of situation arise if these people would be displaced, of course. But it seems to me it's frustrating that this has not been resolved, or any movement or any responsiveness on the part of the owner. And so while I'm in favor of a continuation, I think there needs to be some remarkably hard and fast rules. And I also wonder if the owner should suffer some penalties, which certainly would have accrued over these last 2 years, for failing to respond to these things. I mean, that's my only frustration. I think it's time that we do something that leads to a resolution of this within a reasonable and short period of time, a reasonable period of time. So I would be in favor of a continuation with some specific deadlines.
Thank you, Commissioner Coleman. I too, for both of you to hear, my response to this is that I'm going to be a realist. I'm going to suggest that the very first continuation be for 2 weeks. And the reason being that we need to get it broken down into bite-sized pieces. You fail carrying the first bite-sized piece, then we've got to deal with that and go on and assign additional dates. I believe this won't get solved in one continuation, so I want to be realistic and expect the information to come from you two folks as to what bite-sized pieces we're going to do, and some ideas so that we can look at future continuations of what time needs to be allotted for resolution. Certainly 3 years isn't going to be on the table. And is that an idea that the commission can live with?
Mr. Chair,
Yes.
I agree with your latest comments from Commissioner Coleman wholeheartedly. I think that this needs to be resolved very quickly. The applicant has had, or the violator has had plenty of time to respond to these. I don't think we need to give them a whole lot of opportunity to continue to procrastinate on these items. They need to be resolved. They need to be resolved now. And so a very short time frame I would be in support of, and breaking them down into smaller pieces. Let's look at each individual. What's the most egregious violation? And let's address that one first.
The chair to address a motion. We already have both people standing here waiting. The chair would address a motion for the first continuation of the matter. What would you like to see?
What's going to be a reasonable drop-dead date for what he was talking about? I mean, how long are we looking at this point, realistically?
I think we have to expect the parties to tell us, and so that's why I'm suggesting that the first continuation, in my opinion, needs to be for the next meeting, to tell us what direction we're going to do and what items we're going to go on. And because some of them could take some time, as I pointed out earlier, the item that relates to violation number 8, the multi-dwelling, that's an extensive pursuit.
Yeah.
So I'm suggesting, and I'm not going to make this motion, I'm suggesting we look at this in 2 weeks and we get direction from Kimberly and Jason as to what order we're going to do these things, and the time, some idea of the time. We're not going to be holding everybody and slapping hands over it.
Mr. Chair,
Yes.
some of these violations are probably more critical than others, so planning and zoning should have at their discretion to say these are the ones that have to get addressed first and get down to the minor ones last. Because I think once you tackle the big ones, the minor ones will be a lot easier to resolve. And planning and zoning should have the ability to say, this is the one that really bothers me the most.
You're suggesting that planning and zoning pick the priority, is what you're saying?
I think with their expertise, that would be my suggestion.
Okay.
Mr. Chair, if I could ask Jason, so what is the most pressing issue, referring to what Ron said?
pretty pressing. The ones that could get knocked out within 2 weeks is that we could get building permits for all of the carports. We could have the floodplain development permit amended, so it shows exactly where carport on lot number 1 is, and we can get the building permits all issued for that, or for all of those structures. So that would knock out condition number 2 and number 9. So the last one that would be lingering is for the multiple family dwelling. And then that, like you said, that's going to take some time because it's either going to take another conditional use permit or amend this all together and come back with a PUD overlay.
There's options, in
But
other
within
words.
2 weeks, he would definitely, that's enough time for him to come and meet with staff to determine the way ahead. So I think that would be my recommendation, is that 2 and 9 be addressed, and then the applicant work with staff within the next 2 weeks to come up with a plan for the multiple family dwelling.
I have a question on that, if I can.
Go right ahead.
And I believe Commissioner Rosknecht was asking about the carports earlier. They are under 144 square feet, which would not require a building permit. It was put in as a condition last time that they had to be now permanently anchored and permitted, but normally they wouldn't. And it would be our preference that since they're personal property under 144 square feet, that they be allowed to stay as temporary structures so they can move around and not be made real property and taxed as real property. And when they're under 144 square feet, that wouldn't normally have to have a building permit and be anchored to the ground. They are weighted to the ground now so that they will not blow around.
Megan, did you have a comment you wanted to make on that? Please.
Megan Kruger with the state's attorney's office. As we've discussed before, on the phone last week when we spoke about this, when they become a safety danger to the community, and I would say that these have previously been anchored to the ground. When Dwayne went out there a couple years ago, they were anchored to the ground, and then Mr. Allard unanchored them. So when they were anchored to the ground, they required a building permit regardless of the size, pursuant to our ordinance. And then he unanchored them from the ground, and he's re-anchored them and unanchored them back and forth. Pretty consistent with when equalization comes out to evaluate the property. So it's one of those things that's been an ongoing issue for years at this point. So, and I believe that that condition was included, that they be anchored to the ground. And when they are anchored to the ground, they require a building permit because they were blowing around. According to one of Mr. Allard's own admissions, that one had blown over and it had broken and that they were blowing over. So,
Megan, can I ask you a question? Your office seemed to be in support of a continuation of this at this point. Would you rather see the less complicated issues addressed in a shorter time if we were asking for a 2-week? Is that something you would prefer, or do you want to go for the more difficult or higher priority in-depth one?
yeah, so we had discussed a continuation. I don't know why my email that I received from you was not included in the packet. I had asked for it to be forwarded. Was it in the packet? So I believe it actually was in the packet that
Yes.
you had requested a continuance. So, I mean, we're obviously in favor in him just coming into compliance. This is kind of always a last resort, is to schedule these revocation hearings because, we've been trying for several years to get Mr. Allard to come into compliance with his conditions. So I think that a number of things could be addressed in the next 2 weeks. He could come in and get his building permits. He could come in with the floodplain development, where he could move the structure out of the floodplain. And then additionally, he could come in and meet with the planning department, at least get some applications in for either a conditional use permit or a PUD overlay. So there are certainly steps that he can take within the next 2 weeks that really aren't going to take that much effort on his part.
Thank you, Megan.
Thanks.
The chair would still like to hear a motion so that we can finish our discussion.
Mr. Chair,
Yes.
I guess I would approve for a continuance and reach out to planning and zoning for their expertise and how they want to set which ones are going to get addressed first, and some kind of a time frame to do that.
Okay, is there a second to that motion?
Second.
Discussion.
Yeah, I'd just like to, I think that's excellent, but I think that when they come back with specifics about immediate issues to be addressed, that there also be at least preliminary discussion about the more extended issue, that we do not then say, well, we solved, we've gotten the low-hanging fruit, and now we'll sit back for another year while the more pressing issues are ignored. And that's what I think I'd like to see us avoid. I know some of these can be resolved quickly, but thinking and planning should begin on the larger issue, in my judgment. I mean, that would satisfy me. Something less than that wouldn't.
Right, and I think that the applicant could apply for either that conditional use permit or the PUD.
Right.
And that would, should help alleviate your concerns with
Okay.
that, because that would be plotting of course ahead.
Right.
Any other comments? I'm going to make one, and I guess I'll step on my own toe, but I guess I would hope the motion would spur progress on some of the issues. I would take exception to Mr. Coleman's on the more difficult ones. And that, a year doesn't scare me if we get to the bottom of the major one. In other words, the time is not the critical thing in my mind on the major one, the multi-dwelling. That it be resolved properly is the thing. And it has been hanging fire for a while, so whatever it takes. But I would hope that when they come back in the 2 weeks, that there be some progress on the other ones just from conversation, working together. That's my thought on it. Any other comments? Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. Thank you. Jason, let's see, what's our item here? Number today.
17.
Gotta flip back. 17?
Sure, Megan brought up a good point. These next three agenda items are relatively, well, they are related. If you would like to hear all three of them at the same time, we can certainly do that.
There needs to be a motion and
I would so
two-thirds vote.
move, Mr. Chair.
Is there a second to that motion?
Second.
Moved and seconded that we discuss agenda item number 17, 18 together, that they are related, they're ordinance amendments.
And
Any
19.
discussion on that?
And 19.
And 19, excuse me, you're correct. Hearing none, all in favor of the motion signify by saying aye. Aye. Opposed? Motion carried unanimous, so our 2/3 are met. Go ahead, Jason.
So agenda item 17 is ordinance amendment 22-09 to add section 517, special permitted uses, to the Pennington County zoning ordinance. Essentially what this does is adds a new tool in our toolbox for addressing a lot of these routine conditional use permits that the Planning Commission hears, vacation home rentals. We're talking about RVs as a temporary living quarters while somebody's building a home, accessory structures as principal uses, things like that would now be considered special use or special permitted uses, and it'd be more of an administrative approval through our office versus coming in front of the Planning Commission. So that was the intent behind that, to make it less onerous on the public, less onerous on you folks when you're hearing these items. Ordinance Amendment 22-10 is to amend Section 204, General District Provisions. That more or less adds special permitted uses to the zoning ordinance. And then Ordinance Amendment 22-11 under Agenda Item 19 adds the definitions, modifies the definitions of the special permitted uses to the zoning ordinance. And something I'd like to note too, the fees for special permitted uses will be the same as conditional use permits, and you'll see that at the next meeting as an ordinance amendment.
Yeah, I just don't understand. Any questions for Jason on this? Go ahead,
Jerry
Mike.
sent this out to us early, so we've had a chance to look at it. And there's a lot of gray areas, it would seem to me, in here. Somebody has to make a decision if it's going to be a CUP or if it's going to be this or whatever it is. For example, in applicability, it says use by right and cannot meet specified criteria to obtain a conditional use permit. I guess my only question is, and I know what you're trying to do, and it was definitely simplify things, it seems like it might be a little uncomfortable thing at times trying to figure out which it is and who's going to apply to this thing. I don't know. That's my concern when I look back at all the different things that are in here.
So we did that on purpose, for short-term uses specifically, because a lot of those don't apply. We don't have separate sections in the zoning ordinance to go by for conditional use permits. So that was the intent behind it, and we did define that under short-term uses, D1. I have it up here on the screen for you. As far as what that would encompass, now temporary residence for an RV that I've already touched on, certain accessory structures, talking about the garages prior to a principal structure, churches, public structures, things like that. So we have defined pretty well, I think, what a special permitted use is, but we didn't want to be so specific that we hamstring ourselves, I guess, basically.
Yeah, well, that was, yeah, I know what you're saying.
So
Like
anything
I say,
that's not a use by right,
Yeah.
or anything that's defined here as a special permitted use, would come in front of you in the form of a conditional use permit.
And Megan
Thank you,
Kruger
Mike.
with
Go ahead, Megan.
Megan Kruger with the State's Attorney's Office. So just for a little bit of factual background of what these special permitted uses are, because it's a relatively new thing under South Dakota law. Back in 2021 or 2020, I can't remember which year it was, the legislature did some pretty extensive changes to 11.2, SDC 11.2, changed a number of statutes, added a number of statutes. And essentially what that did is, as Jason said, it gives us another tool in our toolbox for some of these routine things to not have to come in front of you guys. As part of that, we can define what types of things can be special permitted uses, but they also have to meet designated criteria. So, for example, if it's a church that doesn't meet the designated criteria for a church, or generally, I don't think that we have specific criteria for churches. Oh, we do actually. If they can't meet those criteria, then they're still going to come in front of you. So essentially, these are for people that are willing to do all of the things that would normally be in the conditions for their conditional use permit with no question. They're willing to do it. They have no concerns about doing it. It's really a benefit to the public that's willing to follow the rules. And not ask for exceptions. So I think that what Brittany and I tried to do was include those conditions that would normally you would see as a condition of their conditional use permit as the criteria that they have to meet in order to apply for this permit. So that does make it a little bit easier for Brittany and Jason and really the entire planning department to say, well, you have to meet all these things. Can you do that? And if they say no, then they have to apply for a conditional use permit. Because if it's not a use by right, it's a conditional use permit underneath of our
So,
zoning ordinances.
Megan.
Go ahead.
Yeah.
So in essence, what will happen is you will approve all of those applications or that we would have probably approved almost without a second thought.
Yes.
And the only ones we will hear are the people who are pissed off at the decision you've
Yeah.
made.
Yeah, and there's
Is that
there's
right?
still
We're not
yeah
on
there's
YouTube
still
yet.
going to be we added some due process because the statutes don't actually have a requirement to send out letters to neighboring property owners, but Brittany and I and Jason felt that wasn't fair just in general, but also wasn't fair as far as the law and due process. So there is some requirements that we added in addition to state statute, which I think that we were well within our authority to send, kind of information to, I think, did I put adjacent or abutting? I think I put abutting, abutting landowners. So that way, your neighbors are still going to have a say in this process. If it becomes an issue, where the adjacent or abutting landowners want to appeal that decision, it would still, I believe, come before you guys. I'd have to double check because the appeal procedure for different things are different. But it would still come before a body if there was an appeal of that decision. So there is oversight, there is review. It's not just going to be Brittany and Jason just signing off on, whatever they want. But it is an effort to try to kind of minimize these things that you guys would just approve if they came in front of you like that.
Can I wade in here? I had three, while I've got you up there, Megan. If you took C, permit process and notice requirements, and then you've got the application, and you go down the listing. My usual questions about LLCs and DBAs involve that. And I'm just throwing things out there. I have questions on to make it easy for you when you have to process one of these to approach them for conformity. Is that a nice way to put it? And then page 3, F1B, I thought the wording there, it appears to me under that wording, somebody could try to self-extend the expiration, just under the wording. It's up to you guys.
Yeah, and some of that language I know comes from state statute.
Okay.
Because there is a state statute that discusses expiration of CUPs, the grant of a variance if you don't actually establish your use. The same thing with CUPs, and then the same thing, they added special permitted uses.
That might apply to the next one, is page 5, L2, the notice. Under the old days, you had to actually have a person listed and an address or phone numbers, that sort of thing. I just put designated notice agent address, but in other words, it says permit holder. What if you can't find them?
Well, I mean, we usually just send it to their last known address. That's
Right.
that's usually sufficient notice under the law. You have to give some due diligence to try to get a hold of them. You can't just say, "Oh, well,
I
we're
was
just going to
thinking
drop
of
it off in your front
corporations where
yard."
sometimes they become defunct and then they're not taking their mail anymore or answering.
Yeah.
And then you've
Yeah.
got an extended process you have to go to show that you've got notice. And I think we could eliminate that by adding some designated address in the process. But that's the only three things I had on all three, so
Mr. Chair,
go ahead.
this is really a simple question maybe, but in RV, could an RV be a Class A motorhome? And then maybe could an RV also be a 35-foot trailer? I just, we had one example today, and I really, you got the tiny home, you got the park model, you got the camper, you got the motorhome, just a lot of confusion there, and it'd be nice if we could identify which one's what. What does it have to be before
Can
it
I
exists?
answer that? I'd like to answer that because it's really simple. I deal with equipment and stuff. The state, in their guidelines, decides what's going to have a title and a license on it. And that would be the RV. And a trailer is not going to have a license on it to pull it around and a title. It will have instead a different set of circumstances. And to give you a crazy example is even a skyhook that people use for painting, and you see these on, that has a serial number and a title, and you have to put a license plate on it.
See, at the lake, Charlie, they bring in park models.
Sure.
And they have a license plate, and that's only, but these people don't realize that these license plates are only for transportation. And once they get to a site at our development, then the wheels are taken off, they're put on blocks, and
But
then
the
they become.
licenses are temporary that they bring them to the
Right.
site are temporary. I'm talking about where they have a serial number and a plate and a title assigned. And these things are totally different. The one we discussed today, it had a serial number and goes through the state of South Dakota as a vehicle, I guarantee you.
And I know too, so it gets really complicated because if you Google just park model, you're going to see RVs. You're going to see like a traditional RV, you know, what you would think of when you think of an RV. You're going to see RVs. You're going to see tiny homes on wheels. You could even see a regular mobile home. I can tell you my recollection of at least some of that licensing stuff for the state of South Dakota is you have to have a title for a mobile home, you have to have a title for a park model, and you have to have a title for an RV. So it does get really confusing because you're kind of using different words for something that's really the same. And the question is, how do you define it? How do you decide whether you want to allow these to be used for residential purposes? And that's certainly a discussion that we can have, and we can change some of our ordinances. Right now, our ordinance is a little kind of, you know,
Don't you think, though, the tax people would also, do you destroy something, taking the axles off of it, or do you take the axles off of it? And they have a book value. They don't have a per square per diem like a house.
yeah. And the taxing, as far as equalization goes, gets very complicated.
Oh, I'll bet.
I've done some of that work on mobile homes through the equalization, and it does get very, very confusing as far as how you tax this structure. And that's kind of a conversation, I guess, for a different department. But as far as our purposes, if you guys want us to go in and more clearly clarify what these things are, and that simply taking the wheels off of an RV doesn't make it a park model or doesn't make it, you know, whatever, you guys can direct the planning department to do that, and we can change our ordinance. So it's very clear.
Jason and I talked, we've been very consistent in the past for 20 years. And it used to be that when you brought an RV, it was an RV and you had 180 days use, period, for review. You did not have permanent use.
Right, so that's what I'd like to kind of clarify here too.
Yeah.
Like, that's what we're talking about. If you see the section up there, F1, the temporary residence in an RV. So the intent behind this would be to build a house or to only use this for a very limited amount of time.
I don't have a lot to hang up on.
So, and that would be the special permitted use. Now, if somebody were to request something out of the ordinary, like we heard today,
Yes.
that would still come in front of you as a conditional use permit, because that would not meet the definition of what we have here as a temporary residence in an RV.
And I didn't do well staying consistent on that one, did I? What I'm saying is I believe that it's still, an RV is an RV. It's pretty well defined. It's purpose-built.
Mr. Chair,
Yes.
so when a 30-foot camper comes out to our development, the tires come off, it goes on concrete blocks, they skirt it. For assessment purposes, it becomes a building on leased land, and they don't have to, they won't title it no more. They just, it's just the way it's assessed. They will get an assessment notice, and it's categorized as building on leased land. And so that's why it gets confusing to me, because we have about everything that we've talked about, we have them out there in our development. And it's confusing. So when they get pulled there, they technically have to get a building permit. They haven't built anything yet, but it's just it's a matter of education. It's pretty confusing.
Mr. Commissioner, I'm worried somebody's going to have an RV that's a Mercedes, and they pull it up and put it on blocks, take the wheels off of it, and rent a porta potty and request us to take a look at that as an efficiency. And to me, it's an abandoned vehicle. So,
Well, I just think it's important to maybe define what these creatures are so that it's easier to work through the process as going forward.
well, I thought we had a consistent, we used to say that if it was purpose-built, that it was an RV, it could only be used 180 days a year. That's what the planning commission's for 20 years. I'm sitting here 20 years later on one. That's what we used. And apparently that's not good anymore. Sorry. And I don't think that's bringing it up to date, up to the modern society. I don't think I'm that far off of what the neighbors think.
But just again to
Thank
clarify,
you.
that's not what we're talking about with
I know.
this section of the
We got
proposed
off.
ordinance.
I agree with you, Jason. We got off subject. Thank you for putting us back on. That was my job and I didn't do it.
Chair, I
Go
have a
ahead.
quick question for Megan. Have any other counties put something similar to this into use? Do we have a track record on this, or is this something fairly new?
I mean, as I said, this legislation was just passed in either 2020 or 2021, I can't remember. So we are probably the first, would be my guess. I don't think that there aren't a lot of other counties that have a dedicated attorney assigned to their planning and zoning department. So they're just not, they're probably up to date on the legislation, but they don't know how to use it. So, like most things, we're probably going to be the first to use it, and people will just copy us. But no, I'm not aware. There might be, but I'm not aware. Lincoln County and Minnehaha are usually pretty good, so.
Anything else on discussion for the ordinance amendment? Any conversation or discussion as to whether you want to extend one over the other or do a different motion on one? They still have to be addressed separately for the record.
Mr. Chair,
Go ahead.
I'm assuming that if we, for an example, approve 22-09, down the road, if something doesn't work right, we can always go in there and change it. It's just, we won't know until we try it.
Right, and it will be changing here in the near future. I kind of let the cat out of the bag earlier, but vacation home rentals will be, the intent by the committee is to have those as a special permitted use as well. So basically, if they meet the checklist of required items, we will issue them their special permitted use over the counter as an administrative action.
I'll comment on that. In my opinion, what you're going to see becomes this ordinance. It's very related and was well accepted by the citizens, and they pounded on this thing to make it work well. So that would be what, following up on what Jay said, but you're going to see one right away that's under special use, so, or very soon. I assume right away.
Yeah, I think our next meeting is this week or next week.
No, it's this week, Thursday.
So
Yeah.
there's probably going to be very soon. Some
And the
additional
citizens were the
changes,
ones
so.
that worked to help Commissioner Ruskin. If the citizens were the ones that understood the concept and actually kind of ran with it and got tougher on some things and more, I don't want to call it rubber stamp because that's what we get accused of all the time, but more compliant with a checkoff system. Anyway,
Would anybody be opposed to giving us a special use report like you do with the permit report every so often, just so that we are aware of what's going through, how many are actually being done through that process?
I have no problem with that at all.
Good idea.
And you guys can certainly direct them to do that. I mean,
Yeah, I think
have the authority to do that, so.
I think it's a great idea. Yeah.
I would like to see a report.
A good idea.
they're actually proposing, that's very good because the committee proposed a separate site for vacation home rentals and especially on the special use permits, and they'll be listed. And that's going to be part of the coming forward of this. So you're right on the money, Kevin. You're already. Maybe we should look at it overall, though, is what you're saying.
Yes, yeah, not just vacation home rental.
Excellent.
Yeah, special use permit.
Anything else for our two representatives?
You know, as a thought, we've been looking at variances, I guess, over the long haul, possibly of us doing that, and we've asked how we're going to do all this. This is how we're going to do it.
Mm-hmm.
This will eliminate an awful lot of.
Clean up the clerical.
Yeah, I think it's a brilliant move just to give it a shot. I would say we'd pass it and just see how it goes. I don't know what else you're going to do.
It will certainly improve the public's opinion that regularly watches our actions. As I said, that rubber stamp type of thing is going to go away because we are going to see the things that aren't going right through the special use permit process, that don't meet the norms, that don't qualify under things we see as acceptable in the ordinance. And any question at all, they're going to come before us. And that's pretty good.
Mr. Chairman, you never know if the boat will float unless you put it in the water. So I think that's what we need to do.
Anything else on those three items? We do need a motion on each one to move it forward.
Mr. Chair, I make a motion that we pass ordinance amendment OA 22-09.
Second?
Per staff's recommendation.
Per staff's recommendations, correct?
Okay, is there a second to that?
Second.
Moved and seconded to pass OA 22-09 ordinance amendment per staff's recommendation and move it forward on to the commissioners, Board of Commissioners. Any discussion? Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. We're now on ordinance amendment OA 22-10.
Mr. Chair, I move that we approve OA 22-10 per staff recommendation.
Second.
Moved and seconded to approve ordinance amendment OA 22-10 per staff's recommendation and move it on to the Board of Commissioners. Discussion. Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. Now we're on ordinance amendment OA 22-11.
Mr. Chair, I make a motion to approve OA 22-11 per staff recommendation.
Second.
Moved and seconded to approve ordinance amendment OA 22-11 per staff's recommendation. Move it on to the Board of Commissioners. Discussion. Hearing none, all in favor of the motion signify by saying aye.
Aye.
Opposed? Motion carried. On to item number 20.
Item number 20 is the county board report. The Board of Commissioners concurred with the Planning Commission's recommendations from the October 11th meeting.
Okay. Items from the public. The last gentleman left here about 5 minutes ago when we got on this boring ordinance amendment thing. I think he actually was going to talk to us, but I think he gave up. But there is no public present right now. Items from the staff.
Nothing, sir.
Nothing?
Well,
Just a
actually,
question, how's Brittany doing? Fine and following up with you guys?
yeah, last I
Ruling
heard,
the roost
she's-
from somewhere else?
she's recovering well.
Good.
Yep. And I do have one thing for you that I just remembered. So TJ Dorff, we hired him on as our building inspector. We did have a vacancy in the environmental planner position, on-site wastewater treatment system inspections and things like that. So re-advertising that position, we intend them to be more of a planner, involved in staff reports and things like that, maybe some CUP reviews, and not so heavily focused on the on-site wastewater. But bottom line is he applied for that position, and we did hire him into that position. So for the next couple of weeks, till we get that building
So
inspector
you did
position.
it from in-house?
We did, yep. So until we get the building inspector position filled, then TJ will be kind of dual hatting both of those positions. I just wanted to give you an update on that.
Thank you. Items from the membership. I passed out a copy of what we were doing a little house cleaning on earlier, so Megan doesn't have to come out of her chair and discuss. What I wanted to do is, I'm proposing that the Planning Commission look at recommending this become a standard rule or a standing rule. We can't do that on our own. The bylaws are written by the Board of Commissioners, I'm sure, and they are the ones that have to produce any corrections or changes that we do as standing rules. So I gave you this, and it would be something that would be nice to discuss next time. And if you feel we should have a standing rule in regards to abstention, that we should do that and send it on to the Board of Commissioners for handling. Whatever they want to do with it, they can throw it away, do whatever they want. But that was, I wanted to at least put in writing what we had done so you have some idea what you're looking at.
Mr. Chair,
Yes.
I think it's a good roadmap because we won't always be here and you're going to have another commission. And I think it's important that they have something to fall back on to see how we're doing it in the past. And if there's something that's got to be changed, we can always change it.
The reason I wrote it up was because we actually have people that will regularly watch us. And they can get confused to what we're talking about or who's talking and who's addressing what and as what position. And I think that helps avoid that confusion to those that don't come at the meeting or participate in the hard copy type situation. But anyway, we can talk about that next time. I just threw it in the packet that way. You've got a chance to review it and make corrections. Anything else from the membership? Okay. Chair to address a motion to adjourn.
So move.
Second.
Moved and seconded to adjourn, the planning commission. Discussion? Hearing none, all in favor of the motion signify by saying aye.
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 Opposed? Motion carried. We're adjourned.